Good afternoon. I'm Tim Rogers. I'm Police Federation of England and Wales's Pursuits and Driver Training Lead. I'm also the Deputy Secretary in West Midlands. I'm here for the 5th year running to give you an update on where we are with the police driving campaign and how we've managed to address the flaw in the current legislation, which leaves all police drivers vulnerable every time they get in the car, put on the blue lights and two-tones. But I first want to start off with the story of PC Vaughan Lowe. He's a traffic officer from the West Midlands. He, unfortunately, whilst responding to a job, using his training in the way that we'd expect him to, in order to protect the public, was involved in a collision that resulted in the death of a pedestrian. What followed on from there was a 7-year investigation, firstly looking at the criminal side, where he was deemed to have had no case to answer by the CPS, but on appeal, they charged him with death by dangerous driving. He was eventually acquitted at court, but then pursued for gross misconduct proceedings. And as I said, this took over 7 years at a cost of over £1.2 million. And Vaughan is one of the many circumstances that makes us absolutely committed to getting this flaw changed so that officers can go about their duties using the training as they'd be expected to do without fear of prosecution.
In April 2012, I was involved in a road traffic collision whilst driving an unmarked police vehicle. I went to an immediate response with my emergency warning system, abiding by the training I'd been given, and a gentleman ran out in front of the police vehicle, collided with the front of my police vehicle, and subsequently died a day later. I attended Leamington Spa Magistrates Court, where it's the first time I've stood in the witness box as a defendant, and I wouldn't wish it on any police officer. And then to listen to the verdicts, it's the worst time I could ever ask. And I hate for a police officer to stand there in a hurry, because for 5 seconds your life's in balance, because it's either guilty or not guilty, and it's something you never wish on anybody, and I really don't, especially a police officer that's done nothing wrong. So the IOPC, as they're now called, or the IPCC, stood on the steps of the court and said I would face a gross misconduct hearing. That took a further 18 months. With that to go through again and to be found not guilty, I wouldn't wish it on any of my colleagues. I really wouldn't. There was going to be a review done by the IPCC and West Midlands Police into how I'd been dealt with, and there had been failings, and I was sat opposite an ACC who told me that they got it wrong and they'd failed us. And that review was concluded, and to myself and the persons present, it was a paperwork exercise where they said, yes, we got it wrong, but this is what we've done now. And after coming up to 6 years, that's really not an answer to where myself and my family have been. So it's still ongoing, unfortunately. My family is supportive but don't understand why the delays. And still don't, and they're normal, what you would say as normal people, but members of the public, and they don't understand why this takes so long. And again, I've got a daughter who's kept me where I am, and family. My sons have all been so supportive that that's where I'm here today, talking to you. We receive a large amount of driver training to get to the standard we get to, but it doesn't end with one course. It's reviewable, it's ongoing, it's learning with everything you do, and to go through the driver training that I've been through and the learning curve that I've gone through to keep my driver training, to then suddenly be told that I'm going to be prosecuted at this level. We're asked to do a job, we are asked to go outside the normal driver realms, but then are not protected as soon as it does, and inevitably things happen, and automatically then we're reverted back to the normal driver. We're employed to protect the public, which includes MPs, because they're public, but there's nobody there to protect us. And I know it's a minor thing. People say, oh, the legislation won't change a lot, but it will. Because when a police officer goes out to do his job, then he'll know that he's got something in place that will assist him. We're not asking for carte blanche, that we're given the right to do whatever we like. We're just asking for a fair hearing, a fair side to what we do, to take into consideration what our training gives us.
Now, Vaughan was one of many officers who's been through this very type of investigation and demonstrated why it's imperative that the law had to change to protect them. If we cast our minds back to 2005, 2008, the officers' cases which brought this to the fore were Mark Milton and Craig Bannister. And the Bannister case was of particular importance because the High Court ruled that no account whatsoever can be taken of the skill and special training of a police officer. It highlighted the fact that what we've been saying for all those years preceding that and leading up to where we are today, that it's completely inappropriate to judge officers by the standard of a careful and competent member of the public, because we don't expect officers to drive like members of the public. In the same way, we don't want members of the public to drive in the way that police officers do. Thankfully, and obviously we in the Police Federation are very grateful for the support of the government, Home Office, Ministry of Justice, the MPCC, even the IOPC were in support of this. And the significant release and the significant piece of progress that was made was on the 2nd of May 2019. The Home Office released their intention to change the law in recognition of what we've been campaigning for. And what they said was the current laws don't recognise the training that police response drivers undertake, nor the tactics that they may have to employ to respond to emergencies and pursue criminals. Police drivers are currently held to the same standard as members of the public and have to rely on the discretion of the Independent Office of Police Conduct and the Crown Prosecution Service to avoid misconduct investigations and criminal prosecution. Now, how terrible a position is that for our officers to be in, that we're reliant on the goodwill or the political will? We've often seen warm words of encouragement from these officers, usually followed by acts of betrayal, where officers then get prosecuted or taken through the gross misconduct process. But obviously, those words that I've just read out and what you can see on the slide behind me are from the government themselves. So they agree with us and they've agreed to act. So let's talk about where we are with the bill. And obviously, we mentioned the Police Crime Courts and Sentencing Bill, which is progressing through Parliament as we speak. It is going to happen. I've been assured by the Home Office that this will receive royal assent by January next year. And there are some challenges that we still have with it. Keeping a positive note on this development, obviously it's going to help a lot of officers. This would have helped Vaughan in his position because he's got a supportive report saying that he's doing what he's been trained to do in the way he's been trained to do it. And through that, he'll be supported both from a policy point of view and from a legal point of view. But the government's bill introduces a new standard to which police drivers must conform. And that standard, as we've mentioned, is linked to an individual driver's training and, at the moment, force policy. Now, we've got various policies around the country, but we've done an awful lot of work with the MPCC and others to have a unified approach to police driver training. And that formed part of the success in our campaign to get the government to believe that they had the confidence to allow this change in legislation. But it follows that an officer will be licensed to drive according to what they've been trained to do, but no more. Performing a manoeuvre that's not trained or in policy is likely to fall within the new definition of careless and dangerous driving. So that's the new test against the careful and competent police driver. So going beyond the terms of that licence could give rise to criminal liability. And I've grave concerns about the practicality of this approach. In short, policies and training cannot anticipate, regulate, train and licence for every eventuality. What's a police officer to do when confronted with something that falls outside of policy? Such concerns have already been raised with the National Police Chiefs Council and the Police Federation of England and Wales, which have both advocated some form of reasonableness defence to run alongside the current bill. Now, again, we're happy that the bill's going through. We're really pleased with the support that we've got, but we need to do everything that we can to make sure the bill is truly fit for purpose. So in short, I've mentioned this before, the bill in its current format won't permit a police driver to respond legally when confronted by the many and varied situations police officers are likely to encounter while driving police vehicles. The provisions of the bill will, without amendment, encourage officers to decline to engage in situations that policies and training don't cover. Because of the nature of policies, the evolution of offending behaviour, such situations are likely to be common rather than unusual. And I'll come on to explain that a little bit later on. There'll always be a lag between offending patterns, changes in policy, and the introduction of training to deal with the new offending patterns. The introduction of a reasonableness defence to the bill would resolve these issues and provide the flexibility officers will need to respond legally to the matters that they encounter during the course of their duties. I'm going to talk a little bit about our colleagues in the IOPC. Now, as a regulator, they're able to target areas of police policy that it feels are in need of clarification or enforcement. Its approach is public, it's well publicised, and in turn, offenders learn the boundaries beyond which police drivers cannot go. I mean, one such example, and everyone will be well versed on this one, was the example of youths on scooters. Under the policies of the day, the vulnerability of such riders acted so as to implicitly prohibit a pursuit. Youths would chuck their helmets away as they learnt that to do so would further discourage the pursuing officer by increasing their vulnerability. So no surprise there, an explosion of scooter-related crime resulted, and eventually policy was extended to permit tactical contact to stop riders. But at the time of writing, here, today, the situation that all officers face, the law hasn't changed to legalise any change in policy, and it would currently be difficult to resist a charge of dangerous driving arising from tactical contact. Now, of course, when the bill comes in, that will be alleviated, but I'll make the point again, here, today, you'd be really hard-pressed to resist that charge of dangerous drive. So the bill's to be welcomed in as much as it would permit the officer to argue the tactic deployed was not dangerous because it's consistent with policy and training. However, the amendment in policy and training took a number of years to be introduced. And the Police Federation first raised this legislative issue years ago. In the interim, the public has not been as well served as it could have been, with officers being required to stand potentially impotently by or risk prosecution by taking instinctive action. Now, how's it going to work? Now, the government is saying that their plan, it'll be absolutely fine, okay? And I'll give you another example. If you're in a situation where you have to act instinctively and you're unable to do so because you haven't actually had that training, you've got that dichotomy whereby it's malfeasance in a public office if you don't act to assist the public and keep them from harm. But if you don't, if you haven't been trained, then of course that would then leave you vulnerable to the new offence. What we've come up with is a statutory defence to the offence of failing to reach the standard of a careful and competent police driver. Now, I'll just run through a couple of the bits that makes this appropriate. So any defence should regulate the extent to which a driver is permitted to depart from the relevant standard. To avail themselves of the defence, the officer should be limited to action taken that's reasonable and proportionate. So it's in line with Section 3 of the Criminal Law Act. And to what the responder, and this is really topical at the moment with the WA80 case, what they reasonably believe they are responding to and the threat that's posed. And any departure from the relevant standard should be reasonable and proportionate. The proposed amendment is proposed wording of a defence. When a vehicle is being used for a policing purpose, the driver may depart from the standard of the careful and competent police driver or cause another to do so. That's a really important point at the moment. We've had two headline cases with Met officers who've been charged for the actions of others. Now, the government had said that officers shouldn't be held accountable for the actions of the people that they're trying to stop causing harm to the public. So moving on, we see point A, driving the vehicle in accordance with road traffic regulations or relevant policy would be likely to hinder the use of that vehicle for the purpose for which it's being used. And any such departure is reasonable in the circumstances as the responder reasonably believed them to be. And the departure was proportionate to the circumstances as the responder reasonably believed them to be. And in deciding whether the departure was reasonable, the following should be taken into account insofar as is relevant. So we then go on to talk about the relevant training that has been received by the driver, if applicable, that the driver reacting to the circumstances as they occur may not be able to judge to a nicety the exact measure of any necessary action required, and evidence of the driver having only done what the driver honestly and instinctively thought was necessary in the circumstances constitutes strong evidence that any departure from the relevant standard was in fact reasonable. So the campaign so far, as I mentioned earlier, the bill's making progress through Parliament. We have lobbied the Home Office and the government with regard to this. We've provided a compelling base of evidence and also reassurances as well with regard to striking that balance between allowing officers to act instinctively yet not creating too much danger to the public. Now, response driving pursuits, we all know, carry a risk, but this manages that risk, and it would enable officers who aren't trained to still be able to act instinctively to protect the public and keep them from harm. If the bill proceeds in its current format, we will likely have to advise them. If it's not written down on a piece of paper, it's not written down in policy or in the training manuals, then you shouldn't do it, because we're basically going to criminalise a breach of policy, and we'll be the only profession in the entire country that I'm aware of that criminalises breaches of policy. I think if you look at a comparator with the medical profession, for you to do that, it has to be gross negligence manslaughter. So my ask and request of anyone listening to this, all the reps out there, any operational officers, engage with your chief officers, tell them about this campaign, tell them how pleased we are that we've got the support from the government, but implore them that this change in legislation has to be fit for purpose. It can't go through in its current format, because we genuinely feel that it will make matters worse.